Hi everyone, happy Monday morning. I am Carol Williams and I am back with another edition of Beyond the Soundbite where we talk about all things U.S. immigration. So if you know anything about me, you know that the first thing we're going to talk about right now at the very end of March with April right around the corner, middle of this week, is H-1B cap season. We were expecting to hear about the lottery tomorrow, and we probably still will in some sort of official announcement from USCIS. But as of Friday, sort of late evening, we started to see lottery statuses started changing from submitted to selected. So they have clearly run the lottery. Now is the time to check your My USCIS account. If the status has changed from submitted and it is now saying selected, that means you were in fact selected in the H-1B lottery. So again, now is the time to stalk your My USCIS account, log in and check that. So we will see what happens. They have not, it's far too early for them to start releasing numbers. So we're not quite sure how many lottery registrations we had, but as soon as we know that, I'll let y'all know that too. I've gotten that question quite a bit, but they have run the lottery, and we started seeing selections come in late Friday. So good luck to those of you who are still stalking your My USCIS accounts. The next thing I want to talk about is Department of Labor is looking to increase the prevailing wages for H-1B and perm applications. This is not something new that was kind of mentioned before. We just didn't see the proposed regulation. Well, now we have seen the proposed regulation, and it essentially restructures the prevailing wages and skews them higher. And it skews them higher for H-1B, E3s, H-1B1s, and our perm applications. E3s are folks who are applying from Australia. H-1B1s are folks applying from Chile and Singapore. The perm application is that first application for some folks to start the green card process, and that process starts with the Department of Labor. So here's how I am telling people to think about it. If orange is the new black and 50 is the new 40, then level 2 wages are now the new level 1 wages. They have essentially sort of upped and increased the level 1 wage, and so thus level 2, level 3, level 4 will also increase. So we will have a comment period on this. I fully expect Department of Labor to stick with the increase in prevailing wage. Now is the time for companies to look at your wage structures, your prevailing wages, what they have been. If you are above the prevailing wage already, how far above are you? If you were below the prevailing wage and you had to come up to the prevailing wage, I would certainly look at the level 2 and level 3 right now, so that y'all can start some internal conversation about your wages vis-a-vis your H's, E3s, and your perm applications. If you need help with that analysis, feel free to reach out and let me know. I'm happy to help you with that. The next thing I want to talk about is your social media presence. So I've been talking for ages and ages about your social media presence, whether you are filing for a spousal visa, whether you're applying for a sibling, whether you're applying for a parent, whether you're applying for a dependent child, whether you're applying for a non-immigrant visa. The government can and will look at all publicly available information, and that includes your social media profiles. So we've seen recently where they have said specifically that they're going to look at H-1Bs, H-4s, international students. Well, the Department of State has now cast a slightly wider net. They will start looking at K1s, K2s, K3s, Qs, Rs, S, T, and U. So essentially, it doesn't matter what your visa category is. Assume that the US government, if you're applying for any sort of immigration benefit, is going to look at your social media. I don't think it really matters if there's an express policy that specifically mentions the visa that you are applying for. Just assume that they're going to look at your social media. And yes, you can lock your profile and you can do all the things, but just assume that they are going to look at it and act accordingly, right? Living your best life on social media is great if that is what you choose to do, but understand that right now there may be consequences to living your best life on social media. So just keep that in mind as we all post on social media and share tidbits of our lives. And the last thing I want to talk to you about this morning is the EB2 NIW. So the April Visa Bulletin allows for EB2s to be filed concurrently with their adjustment of status applications for everyone, except for individuals in India or individuals from India, China, mainland-born China, and the Philippines. So that's kind of the rest of the world, right? So if you're in the US in the month of April and you have wanted to self-sponsor your EB2 NIW, or you're an employer and you want to sponsor one of your employees for a national interest waiver, you can do that and you can file. You can file not only the national interest waiver, but you can also file the adjustment based upon the visa bulletin. National interest waiver is not easy. It's not a slam dunk. It's not guaranteed to get approved. They're very complicated, complex applications. But if you qualify, now is certainly the time to look at and take action. So national interest waiver, as we know, it's a green card category. It's a second preference green card category. So you need to show that you have a master's degree or higher, or if you don't have a master's degree or higher, you can show that you have a bachelor's degree plus 5 years of progressive experience to equal that master's. You have to show that your proposed endeavor has substantial merit and national importance, national meaning to the US. Second, you need to show that you as the individual are well positioned to advance the proposed endeavor. So what are you going to be doing with this proposed endeavor if your green card is approved? What is your plan of action? And last, we need to show that on balance, it's beneficial for the US government to waive the normal EB2 requirements. So the normal EB2 requirements are that perm application where we advertise for the position, we test the US market, and when we see if there are any US citizen or current green card holders qualified for that position. So that is an EB2 NIW. And as I say it, maybe it sounds, oh, that sounds so easy, but it is a complex application to put together. But if you think you qualify, if you've been thinking about an EB2 national interest waiver and you're in the US, now is the time to think about that very, very carefully, because you are able to file your EB2 national interest waiver and your adjustment of status application at the same time in April. So that is all I have this beautiful Monday morning. If you have any questions about the visa bulletin for April, national interest waiver, if you qualify, is that something you want to move forward with, your social media presence, the Department of Labor new rules, and the H-1B cap and the lottery, feel free to reach out. I am here. My office is here. We're happy to help. So have a great rest of your Monday and a beautiful rest of your week.